Hello, everyone. This is Mary Jones. I'm Senior Education Consultant with Husch Blackwell's Education Group. Welcome to today's webinar about COVID-19 and the impact it has on education institutions. So before we begin, I'd like to cover a few housekeeping items to begin our webinar. At the bottom of your audience console are multiple application icons for your use during the program today. Let me just take a minute to highlight a few of these icons for you. There's an icon to assist you with your viewing preferences. Also note that you can expand the slide area by clicking on the Maximize icon at the top right of the slide area or by dragging the bottom right corner of the slide area. If you have any technical difficulties, please click on the Help icon. It has a question mark and provides information regarding common technical issues. Those usually include pushing F5 to refresh your screen and making sure that you're using a Chrome web browser. Additional resources or materials, if they're available, will be in the resource list icon that looks like a folder at the bottom of your screen. And you'll notice, if you've been on our webinars before, we usually have a question box, but for this particular webinar, we asked you to provide your questions ahead of time. And we did that through the webinar invitation. So thank you so much to everyone for your questions. You gave us a lot of what's on your heart and mind as you're thinking through these issues today, and so we want to thank you for that. This program is pending continuing legal education credit for Illinois, Iowa, Missouri, Nebraska, Tennessee, Texas, and Wisconsin. And once the program's been approved, we'll update the link with a certificate of attendance that you'll receive in an automated email tomorrow. To report your hours in Illinois, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. And you may also download the certificate of attendance from the certificate widget at the completion of today's program. A recording of the webcast will be available tomorrow for watching and sharing. And once available, a link to the recording will be emailed to you. Our speakers today include many from our higher education team. With more than 30 attorneys, our higher education law group is one of the largest such practices in the United States. Our group includes attorneys with decades of experience resolving the most complex challenges confronting our colleges and universities. Several of our attorneys have gained valuable industry insights while serving as in-house counsel at educational institutions, major corporations, and government agencies, including the U.S. Departments of Education and Justice. Today, we've invited several of these attorneys from all over the country to address the questions that you've submitted. We've arranged our webinar by topic, and to save time, each attorney will introduce the next speaker. We received a lot of questions and a lot of topics, and we know these are challenging days for everyone on our webinar today. And as we went through these questions to prepare our webinar, it's clear that our participants today, we know you want your campuses to be safe. But we can also tell that you want to mitigate risk, that you want to understand the compliance requirements, and you want to plan for an uncertain future. And because everything seems like it's a moving target during these unprecedented days, you're looking for some guidance. So I'm ready to turn this over to Haley Hansen. She is the leader of our higher education group here at Husch Blackwell. And Haley, these are remarkable days for us, and we are looking forward to hearing from you as you help us to unpack all these topics today here regarding COVID-19 and the impact on higher education institutions.
Thanks, Mary. We appreciate everybody being able to attend the webinar today. Before we really get started on topics, I want to make sure it's clear for everybody on the call that we solicited questions from a lot of institutions. We got a lot of feedback, and we certainly appreciate that. As we are moving forward to the questions today that you asked, there may be a need at your institution to have a more in-depth analysis for your particular situation, and we really encourage you to work with your own legal counsel and work through these issues at the institutional level, but hopefully get some guidance as to what steps should be taken from listening to this webinar today. So I'm going to cover the Clery Act. And the first question that we've gotten from a lot of our clients is, what guidance do we have from the department regarding Clery? So the department has been fairly clear that emergency notifications should be issued if you have an employee or a student who's tested positive for coronavirus. And that emergency notification needs to go out to the segments of your campus community that are affected. And as you look at the requirements for an emergency notification, you need to include as much information in that notification about information that, number one, is not personally identifiable to anyone, but number two, includes information that would allow the person that's receiving that information to protect themselves. And so be very clear about who you're sending it to, and we really say err on the side of sending it to your campus community if you've had an individual who has tested positive for the coronavirus. One kind of follow-up question to that I want to address as well is, what if we've had multiple students who've tested positive for the coronavirus? And the department has said you only send out the first one, and that you make sure that your campus community is notified after you send out that first notification that you've had a student or an employee who's tested positive for the coronavirus. The next question we've gotten from a lot of our institutions is, will there be strict enforcement of daily crime log requirements under Clery during the pandemic? And the answer we've gotten from the department is to do your best and continue to update the daily crime log, but we have heard that there is likely not going to be strict enforcement at this time because the department understands there's lots of demands on individuals' times in terms of emergency planning and preparation that you may not be able to get to the daily crime log. So continue to add your crimes to your daily crime log. Do them as quickly as you can. Some institutions have chosen to publish those on their websites. Others, again, it must be available to the public upon request when that request is made within 2 days of the crimes that have occurred. So remember those obligations. The last question we received regarding the Clery Act is whether an email from your president or your chancellor or other types of COVID-19 communications can substitute for an emergency notification. And the department said no, that is not going to be a substitute for an emergency notification, and in fact reiterated that if you do need to send out an emergency notification under Clery because you've had someone who has tested positive, then you need to meet the requirements of an emergency notification. So you need to include information about the emergency. You need to include ways in which the recipient can protect themselves, so talking about social distancing, hand washing, all the other things that the institution is doing to protect the community. That needs to go in the emergency notification, and it needs to be delivered in the same method that your institution is used to sending out emergency notifications. So that is not an email from the president or chancellor. What you can do, though, is in your emergency notification, you can provide a link to more information. So if you have a COVID-19 webpage, if you have other communications from your president, from your chancellor that have additional information, you can link that information to your emergency notification for more information. And the last question that wasn't asked in preparation for this webinar, but I do think is something that's on everyone's mind, is whether or not the deadline for October 1st for annual security reports will be moved as a result of COVID-19. And so far, the department is saying that they have made no decision to extend that deadline. It's something that they would talk about, and I think depending on how long the situation lasts, that question may come up again as to whether or not that deadline will be moved. But for right now, October 1st is still the deadline. So I would remind anyone responsible for Clery, this is a very good time to send out requests for crime statistics to non-campus property locations, and even for your on-campus property to be making those requests and gathering those crime statistics. And with that, I'm going to transition to Sean Tassi, who's going to talk about FERPA. Sean?
Thanks, Haley. For those that don't know me already, I'm Sean Tassi. I'm a partner in the Higher Education Group in the Kansas City office. I'm going to address two topics today. The first relates to the disclosure of student personal information, and the second, completely unrelated question, is about government commandeering. Before I talk about the specifics of the FERPA question, as a baseline for those that haven't seen it yet, Ed published COVID-19 guidance related to FERPA earlier this month. The FAQs are available on Ed's website, and we have provided a link to those FAQs on our firm's coronavirus toolkit page as well. One of the FERPA questions that we received relates to whether student education records may be disclosed without consent to public health departments where the school believes that COVID-19 poses a serious risk to the health or safety of a student in attendance. The short answer is yes. Although the general rule is that FERPA requires consent prior to disclosure, the statute and corresponding regs contain several exceptions, one of which relates to health or safety emergencies. If you'd like a citation to that, it's 34 CFR 99.31, section A10. Although the short answer is simple, I wanted to key in on some of the practical mechanics of the exception as contemplated in the regs and highlighted in the guidance to help you with additional questions that may arise about the exception. Part of the mechanics are described, if you need a citation, in 34 CFR 99.36. First, the health or safety emergency exception does not provide for a blanket release of information. It's limited to information relevant to the emergency and for the period of time that the emergency exists. To that end, it doesn't apply when the institution is just contemplating a possible threat related to COVID. It needs to be an articulable and significant threat to the health or safety of the student or another individual. Additionally, the institution needs to make the decision on a case-by-case basis after evaluating the totality of the circumstances. Certainly input from the health departments or local authorities would be very relevant to your analysis, but it needs to be an institution decision. Notably, the regs and FAQs reinforce that this is a flexible standard. Ed acknowledges that, and the department is not going to second guess the institution's decision as long as that decision is rational based on the circumstances. So hopefully that gives you a little comfort. Lastly, it's important to remember that after the disclosure is made, the institution is required within a reasonable period of time to document the disclosure in the student's record. The notation should include the articulable and significant threat that formed the basis for the disclosure and to whom the disclosure was made and the date of the disclosure. Hopefully the analysis portion of this Q&A will help you work through other scenarios involving disclosure of FERPA-protected information based on this health and safety emergency exception. With that, I'll let John Borkowski discuss a related topic.
Thanks, Sean. I'm John Borkowski, and I'm a partner in our education group at Husch Blackwell and part of our Chicago office. I'd like to talk about some broader privacy issues that are related to the FERPA analysis that Sean just provided. While there are health and safety exceptions to FERPA's protection of student information, as well as to many workplace laws and regulations protecting the medical information of employees, and as we've discussed, these exceptions may be invoked to provide important information to authorized personnel, what about the interest of the broader community in knowing more about the spread of this infection? Most of your community members, like all of us really, are probably hungry for information that might affect them in this pandemic. And information about exposure to the infection, as we've learned from the experience of other countries, can be medically useful. However, most of the time, you're better off treating personal information confidentially. How then do you respond to the real demand for information? Well, if you think about it, most of the information people need can be provided without identifying an individual. For example, if you've made the decision that information must be shared more broadly than allowed by the health and safety exception, try saying something like, quote, a student who resided in Smith Hall has been confirmed to have COVID-19, close quote. Or if the affected person is an employee, say something like, someone who works in the Jones building has tested positive. And one other final practical suggestion. If at all possible, get an individual's permission before sharing identifying information. In these trying times, I think many people will see the value of doing so and may authorize disclosure to promote the greater good. And with that, I'll turn it back over to Sean.
All right.
Thanks, John. That brings me to my next question, which is, can the government require an institution to provide access to resident halls for hospital beds or supplement medical facilities? It's a really good question. The short answer is yes, and that the institution should be entitled to compensation for the commandeering. The analysis, however, is a little more complicated, but for the sake of simplicity, federal action would be permitted by the Takings Clause of the Constitution and should ultimately require compensation that is equivalent to the value of the property that is being deprived. Some states have similar powers and similar reimbursement obligations. In the event that your school is contacted by federal or state authorities, we understand that things will be moving very quickly, but our high-level advice is to work through your legal counsel as much as possible and make clear that the institution will cooperate, but it does not view the commandeering as voluntary and expects compensation for the taking. What that communication looks like will depend greatly on the exact circumstances, but the goal is really to preserve your rights for future disputes if necessary. That's the primary goal under such circumstances. You know, relatedly, some institutions are working with local hospitals to help provide some additional space out of an agreement with the hospital. If that's something your institution is considering, again, we recommend that you work with counsel and create an appropriate agreement that will govern the relationship. Common terms of that agreement are going to include a definition of the space, the services available in the building, payment, remediation, liability shifting, those types of things. The exact circumstances will again depend on the arrangement, but the terms should really be determined before the relationship starts. I think that will help avoid future questions and disputes. So with that, I'll turn it over to Annie Cartwright.
So speaking of healthcare, a lot of you have healthcare education programs that are facing particular challenges right now. We've gotten a lot of questions about how in the world are you supposed to test clinical skills and make sure that your students are able to do the physical tasks that you're typically testing them on, either in simulation centers or in their clinical rotations. And the first advice we can give is consider your accreditor requirements. A lot of healthcare programmatic accreditors are being flexible around skills testing given the crisis. Although we found that some are not, those may simply be the ones that are slower to respond because over time they all seem to be getting flexible. When it comes to testing those skills, be creative. For example, we've seen one school that is having its nursing students videotape themselves performing non-invasive skills demonstrations on family members. Of course, they're following their lawyer's request for appropriate releases and waivers from the students and the family members, but that is one way to test what you would otherwise test in a classroom or simulation environment. For simulations, some schools have decided that they're vital and they are engaging in socially distanced exercises with one student in the center at a time and very careful CDC-approved cleaning procedures. As one client put it recently, if pilots can learn to fly fighter jets on simulators, shouldn't our healthcare providers who are desperately needed at this time be able to learn on simulators? So consider the extent to which you can deliver the clinical skills that way. When it comes to written exams, try to be flexible. Consider giving oral exams through a live video feed. That may reduce some potential for cheating because you can observe the person full time when they're doing that. Ask yourself whether you can wait to give written exams if you don't have a student that you're trying to get out into the workforce. In light of the Department of Education and accreditor flexibility around the length of your terms, can you wait and give those exams at a later time? NCLEX is working on socially distanced testing for nursing students. They're shortening the exam time and they're even letting students wear PPE during testing. That may be an option for you. If you do simulations or testing, run your procedures by your health department to make sure you are aligning with their expectations. Note that we are seeing some states, Louisiana, Massachusetts, New York, California, among others, and licensing boards and healthcare accreditors push towards advancing students, particularly those more senior students, out into the pipeline, and some are considering provisional licensure situations where even if they haven't had their clinical rotations, they can get a provisional license and get out into the workforce. So with that, I will hand it over to John to talk about more creative ways to deliver education.
Thanks, Annie. I would now like to highlight a couple of civil rights issues that may present some somewhat different challenges in the current environment. The first, and perhaps most obvious such issue, is the accommodation of students with disabilities. Many of our clients are finding that online education presents different accommodation challenges. One major area of concern, of course, is web accessibility. It's more important than ever to have a coordinated, institution-wide plan for compliance, including addressing how to provide the right IT support to the many brand new online content creators that you now have in your communities. The second civil rights issue that presents some different concerns in an online educational environment is harassment on the basis of race, sex, or national origin. For example, one school with a significant Chinese student population recently had to address a situation in which a student posted racist anti-Chinese comments. This presented issues not only under the school's code of conduct, but also potentially under Title VI. And remember, for those of you at public universities, this scenario also presents competing First Amendment concerns, including potentially complex questions about the precise nature of the forum in which the comments were made. These are just a couple of the federal civil rights issues that have different twists in an online environment. With that, let me turn it over to my Chicago colleague, Pete Land.
Thanks, John, and hello, everyone. I'm Pete Land, and I'm going to address two questions. The first question is, what are the key issues to consider when conducting investigations remotely? My comments can be applied to investigations of student or employment issues. And there are two basic points to make about investigating without in-person meetings. The first, briefly, is to talk about timing. We still want to adhere to the time limits that exist in our policies and procedures, even in these times, and we want to communicate well when that is not possible, but really try to stick to those timing guidelines even when we're doing remote investigations. And the second issue is a little meatier, which is how to interview people remotely. You can either use phone or video conference, and while phone interviews can work, they're not usually the best approach for key parties or witnesses, because the visual cues you get when you can see people are helpful for a better exchange of questions and responses and to build rapport and thus generate more effective information gathering. So you really want to use video conferences for most interviews and understand that people have less experience with this approach, so investigators need to get used to doing it. The three main transitional points for investigators are technology, communicating in advance of interviews, and conducting the interviews themselves. With respect to technology, Zoom, Skype, or WebEx meetings are common platforms to use, and investigators should get comfortable with them. They should practice and be ready to be the person who can explain to the witness how to make the connection work if they need to. Should also understand privacy concerns and know how to lock a meeting once it starts to prevent anyone from joining. And they should be very familiar with document sharing and have a plan. Usually that involves sharing your screen with a document on it during the interview. It's easy to do in several platforms. And it helps avoid sending documents in advance to the witness so they can study, or sharing documents in a way with the witness during the interview where they could keep them and risk confidentiality concerns. The second video conference idea to keep in mind is pre-interview communication. And you want to have a lot more of this, if you can, than an in-person interview to help calm the witness about getting used to using the technology. And it makes the information gathering more effective if they're calm. You also want to ensure the witness knows how to use the technology platform, how documents will be used, and explain dress code expectations preemptively so they understand they can wear comfortable clothes or business casual and aren't worried about it. It's also important before the interview starts to seek to maintain some control of the interview environment by clarifying in advance who will be present on your side, who can be present with the witness, explaining there shouldn't be anyone else there unless they've identified an advisor, and that no one should record the interview on the witness's side. And if the investigation process involves recording, clarify with them how you're going to do that. You should also explain to the witness to be able to prepare to participate from a location where other people cannot hear the conversation. With respect to interviews themselves, the third part of video conferences, you want to plan to build rapport time more deliberately. It's always important to get witnesses comfortable and avoid their nervousness by building rapport, but it's more important with new technology, which they're unfamiliar with. And you may want to map out exactly how you're going to do that and really try to avoid bringing up any COVID-related issues, but be ready to talk about them if the witness wants to discuss something related to transitioning from working from home, as to put them at ease. And then you want to reiterate expectations for no recording and that no one else can hear or is present during the interview itself. Other than that, you want to conduct the interview as normally as possible. And these are considerations we recommend for remote investigations. Now, our next question relates to accommodations, and do employees working from home need to receive the same accommodation they received when working on campus? Generally, institutions should presume that employees may need the same accommodation, but not in every instance, and schools may want to choose a different accommodation if a less costly option exists that meets the needs of the employee. The EEOC issued guidance on COVID-19 pandemic issues on March 19th. That provided the following. If an employee with a disability needs the same reasonable accommodation at a telework site that she had at the workplace, the employer should provide that accommodation absent undue hardship. In the event of undue hardship, the employer and employee should cooperate to identify an alternative reasonable accommodation. Now, the contingent nature of that guidance, where it starts with if an employee needs the same accommodation, reflects the fact that the change in context of a work environment can change the accommodation analysis. It also reflects the principle that an employee's preferred accommodation is never required if an alternative meets their needs. That is up to the employer. The same approach applies when someone's working from home, but each institution should always engage in dialogue with the employee if changing accommodation or choosing an alternative. Also, no accommodation that creates an undue hardship is ever required. Now, undue hardship is based on financial cost. It's generally hard for employers to rely on, but it can apply, and it can consider non-financial difficulties too, such as accommodations that are substantially disruptive to the operations of the business. It's hard to know how that standard would be applied to the mass transition of many employees to working from home for a temporary period of time if they seek costly accommodations, but it's worth thinking about more carefully than we might otherwise. The takeaway is to ensure any accommodation request for a work from home employee is considered on a case-by-case basis, evaluating the particular employee's work from home logistics, their functional limitations, and the essential duties of their job. And it's important to document efforts to communicate about that decision in an interactive way. Now I'll pass along to Scott Schneider to address other ADA-related considerations.
Thank you, Pete. This is Scott Schneider, and I'm going to continue the conversation about disability accommodations. So the first question I have here is, does all of our programming have to meet web accessibility requirements? And the short answer to that question is yes. And it's at least worth pointing out that we've learned quite clearly over the last couple of weeks that not all learning management systems are built the same and that they vary in terms of their accessibility. Just by way of example, some learning management systems aren't accessible to students who use assistive technology. To the extent you have concerns about this, we think it's super important to check in with your campus disability resource office to assess these and any other accessibility concerns. Regarding the second question, what other disability concerns should we think about as we move to online programming? I'm going to point you in the direction of a really good resource. The University of Maryland has put together a really helpful resource. It's on the web. It's through its Division of Information Technology, and it's called, quote, Keep Teaching. And in that document on that web page, they identify various disability-related issues and provide faculty and administrators with guidance on how to navigate those issues. Of course, I'd add one more super important piece to this. I think it's essential that we make plain to students with disabilities that if they are having accommodation concerns as we transition to web-based educational programming, that they need to communicate that to the appropriate personnel within the school for handling. Even with the best planning, it's hard to anticipate all of the potential issues that may come as we rapidly move to online course delivery, and it's just super important for schools to be receptive and responsive to student needs in that space. All right, so the next slide is about Title IX, and what guidance can you give us around reasonable delay or requested delays in Title IX investigations? Well, I'll start with the easy stuff. Two things are certain. Number one, we can't issue a blanket policy or practice of postponing all investigations until students and administrators return to campus. That's not going to work. And the second big picture point is whatever we do in terms of affording accommodations or denying accommodations needs to align with our own institutional policies. Thinking bigger picture about this, I think it's important to take a step back and recognize we have three obligations, broad obligations in handling these investigations. We need to be prompt, we need to be thorough, and we need to be equitable and fair. It's also, I always point out, important to recognize that, as always, there's some tension between these three competing big picture considerations. From my perspective, the COVID-19 situation may present some unique challenges in terms of setting up interviews or securing meaningful documentary evidence. To the extent information which is critical to the resolution of an investigation is difficult to get now, for instance, a critical witness is ill or can't be located, but that information may be available in a reasonable period of time, I recommend that we document our efforts to secure the information or the witness interview and then hold off finalizing our determinations until we've established a comfort level. We've done all we can to conduct a thorough and fair review. Put another way, reasonable delays should be accommodated, and again, to the extent our policy allows us to, especially if the delay allows an institution to obtain critical evidence and there's no evidence that the delay is unduly prejudicing either party. So now I'm going to turn it over to my colleague, Annie Cartwright.
So shifting gears to another way we can care for our students beyond enforcing our non-discrimination policies is Title IV, or federal student aid. How can we help our students in this area? We've gotten a lot of questions. There's a lot of guidance, a lot of new legislation in this area. The biggest push is that you can offer emergency aid that will not offset future financial aid awards. You can use your federal work-study dollars and transfer them to federal supplemental educational opportunity grants, or FSEOG grants, up to just over $6,000 per student. And under the Higher Education Emergency Relief Fund payments, you need to use half of your awards for emergency aid grants for COVID-related expenses. It's my opinion that you can do this regardless of a student's Pell eligibility, so regardless of whether a student is an extreme needs student, and you can do it for graduate and undergraduate students for COVID-related expenses. Next up, some students unfortunately are going to need to withdraw during the emergency. They can get some relief from what are otherwise negative impacts of withdrawal. They don't have to return Title IV funds. They don't have to pay the what are known as R2T4 dollars back, but note that your schools need to go through some of those R2T4 administrative requirements to track the withdrawals. Also, if your students are having issues with satisfactory academic progress, you can remove from the SAP calculations attempted credits that were not completed because of COVID-19. And finally, students who withdraw won't have the aid for the, quote, semester or equivalent of the COVID-19 outbreak deducted from their lifetime subsidized loans and Pell eligibility limit, so it won't count towards their maximum aid dollars. Where institutions opt to do so, federal work-study students can be paid to do their jobs even if they are not working due to closure or moving online. And the CARES Act pauses all federal student loan and interest payments until September 30th without penalty. That means students may stop paying or borrowers may stop paying without penalty or late fee during this time, and no interest will accrue, and student loan debt collection has been halted for now as well. The stimulus package also provides some incentives for employers to support students by expanding their ability in what was previously tuition reimbursement to allow employers to sponsor students' loan repayment up to $5,250 per employee. And finally, teachers with teach grants can be excused from some of the strict terms that would otherwise convert their grants to loans. So those are the benefits to students in terms of federal student aid. Another question we have gotten repeatedly is whether we have to offer room and board refunds or you can offer room and board refunds. Know that some schools are providing at least partial refunds for housing. Whether they're required to do that is going to depend on the language around their room and board agreements and any related policies, whether in particular you have force majeure language. While the law hasn't been tested here, conceivably you would be in a better position to avoid potential liability if you didn't force students off campus as opposed to requesting them to leave. So letting them know you would still provide the services you had agreed to provide. But obviously safety issues have been paramount in recent weeks, quite possibly implicating some sort of force majeure clause or other potential exemptions that might excuse institutions from making refunds if that's not something you're in a financial position to do. Know that offering refunds can certainly help offset increased housing costs that your students may have. And it may possibly limit any future breach of contract claims against your institution. Work out with your financial aid office, however, the way in which you offer any refunds to make sure it doesn't reduce future aid for students in future years. If you offer a refund, it can create a Title IV credit balance that has certain requirements around payout and use. Your financial aid office should understand that. Title IV credit balances cannot be carried into the next year, but they can be used to pay in advance for next year's tuition and fees. Under current department guidance, if you offer a refund this year, it won't impact a student's financial aid for next year. But if you wait and you offer a refund or a credit towards next year's charges, as the guidance stands at the moment, it will count as estimated financial assistance, which is in effect an institutional scholarship that could lower a student's future aid award. Remember that you have emergency aid options that we just talked about. They could be combined with refunds or credits and may achieve the same goal without offering a typical refund that you would otherwise offer under other circumstances. The last thing I want to note, and I will thank the clients who noted this for me today, if you do use your relief dollars to offset room and board refunds, you could conceivably limit the amount of recovery that you might otherwise have available under a business interruption policy because you would be using government funds to limit your losses that the insurance might otherwise pay for. So with that, I will hand it over to Derek to talk a little bit more about room and board issues.
Thanks, Annie. Well, I've got a few contracting questions that we've received from a number of our clients, and the first one that has come to us in many different ways is, does the COVID-19 outbreak allow us to break our contracts with vendors, whether that's food service or maybe contracted campus security or custodial services? So whenever you ask a lawyer, what does my contract allow me to do, our first response is going to be, look at the language of the contract. Depending on the level of sophistication with which your contracts are written, they may contain specific language governing the party's rights when there is an unforeseen event. Sometimes that's called an act of God clause, or it could be called something named a force majeure clause. But in essence, in more sophisticated contracts, the parties actually lay out in writing what their obligations will be if there's some unforeseeable event, like an earthquake, a hurricane, an outbreak of a virus like this. So that's the first answer to the question. Look at your contract and see if it has language. It may have specific language that allows the parties not to perform the contract. In other words, for you to stop paying if there is some unforeseen event. If that language isn't present in your contract, there still may be a defense to a breach of contract claim if you were to stop paying a vendor or to disengage with them. The law recognizes a couple of different doctrines. They're called the doctrine of impossibility or maybe frustration of purpose. And in effect, this is when something unforeseen and for which you are not responsible for makes it impossible for the parties to perform a contract or for you to receive the benefit of that contract. So taking as a hypothetical example, if you had a contract with a custodial service for the sole purpose of cleaning your dormitories for the remainder of the semester, and local authorities have ordered you to close your dormitories and to shut them up, you might argue that it's impossible for you to receive the benefit of that contract because the dorms are closed, and therefore you don't have to perform. These are specific questions that need to be answered by your attorneys based on the law in your state, but these are possible defenses to a breach of contract action. So the next question is, we haven't yet sent out our housing contracts for the next academic year. Should we make any revisions in light of COVID-19? I think the answer to this is, at a minimum, you should review the draft contract and see if it's sufficient. Some housing contracts that are well written have those force majeure or act of God clauses already in them. If they don't, this is a great reminder that they probably should be revised to include some language about what the obligations of the school will be in the event there's some reason why the dorms have to be closed. Also remember that we're all under the assumption that these stay-at-home orders will be lifted by summer, but it's possible, especially in certain states that have a high incident of infection, that they may even continue into late summer, early fall, and you may want to build in some language in your housing contract that speaks to that eventuality, that you're not guaranteeing housing, especially if the local authorities are not permitting it. So now would be a great time, if you haven't sent out those contracts, to revise them to try to address some of these concerns. And the last question, we're currently in the process of renegotiating a key vendor contract. Should we delay signing it? I'll give you the lawyer's answer. It depends. If this is a vendor service that could be significantly affected by when we come out of this COVID outbreak or the lasting effects of it, so like food service or maybe custodial services for housing, maybe vendor service for sporting events, then yes, if you have the ability to hit pause and sort of let this play out for a while and see when it's going to